A very good day to Dr. Aswang and my fellow classmates. Today, on behalf of the Professionalism and Ethics in Psychology subject, my group and I would like to present our topic, which is ethical issues in confidentiality for children or adolescents in attaining psychological counseling. My group consists of 4 members who are Nur Alia Iman, Putri Jasmina, Tengku Nazran, and myself, Dashin. Okay, so the topic of confidentiality for children and adolescents in attaining psychological counseling has a lot of legal and ethical implication, along with active discourse with major concerns regarding the involvement of parents, as well as the client-counselor relationship. And in this presentation, we'll be going through some of those implications, along with some of the discussions that pop up when we talk about this topic. But before we do that, we first need to understand what is confidentiality. So what's confidentiality? So confidentiality is the protection of one's secrecy. So your personal information, your personal data, client's personal information, and whatever a client discloses in a session has to be kept confidential by the counselor. And that is confidentiality. And it's also to respect the trust of the client and to not disclose the client's personal information to third parties. By doing that, you're respecting the client's trust. And why is it important? Why is it such a concern? It's to build the trust between the client and counselor. It's to help grow that client-counselor relationship. And along with that, it also helps provide a safe space for the client to open up. It makes them feel more comfortable and make them more willing to share things that are more personal, that are more deep to them. And it's also good to maintain a good counselor integrity. So basically, you keep your counselor reputation healthy by being ethical, basically. So that's what it means to have a good counselor integrity. And it's also to respect the client's information, because after all, the clients have rights that need to be respected. And the history of child clients. So child psychology has been established in 1840. However, in its early stage, it's more towards experimental and learning about the development stage of children and adulthood and teenagers and all that. So there weren't really child clients. Child clients are more of a modern thing and more of a recent intervention that came up. And also in the 1840s and way back when child psychology was just in its coming up stage, there were a lot of practices that could have been deemed unethical by today's standards. For example, the electroshock therapy, the monster study where they verbally abuse children who stutter and that makes them stutter more. So that is verbal abuse. Electroshock therapy is physical abuse. And then there's also sexual reassignment, which is psychological abuse, where there's this one case where they make a boy act like a girl, tell the boy that he's a girl when he's actually a guy, which ended up in a suicide actually. So those are all considered unethical and very highly unethical actually, and violations of a child's rights. And today a child can get counseling easily, and it's very accessible for them to get counseling, and it's highly beneficial just for their general well-being. Along with also it helps them with if a child is going through bullying or other like toxic stressors in their life, in their environment, then counseling can really be beneficial for them. So we'll get more into this here. Child clients in counseling and psychotherapy. So counseling sessions where a child has a one-on-one with a counselor and they talk about whatever that is that they want to talk about. And this helps the children cope with problems that they can't handle alone. So whatever personal problems they have, they can unload on the counselor and just discuss that. Also helps with prolonged problems that affect their daily life. So this is more towards like if a child is facing difficulties in their daily life, like for example ADHD. A lot of children with ADHD, they face difficulties and they don't realize it sometimes. And having a counselor in that case would be very beneficial, if not mandatory. And also having healthy conversations where children can talk and be heard. So in a familial setting, in a house setting, it's very hard to be as open as you would with a counselor, where you know the things that you say are going to stay in the room, and that's why confidentiality is important again. And then there's also this play therapy for children, which is more common for children to go through. And in play therapy, there's a lot of field in play therapy. There's a lot of exercises that they can do, and there's different exercises that do different thing, but generally it helps with stress. It feeds into that children's natural urge to explore and discover things, and it also helps with cognitive development. That's the main thing, is the cognitive development, problem solving, and schema and all that child theory stuff. So that's play therapy. So moving on, and now we come to the child client's confidentiality. So when a child goes through therapy or counseling, and a child is considered to be someone who's under the age of 18 and under the responsibility of a guardian. So that's the definition of a child. And when they go through counseling, parents have to sign an agreement to respect the confidentiality between the healthcare provider and the minor. Because if not, a parent could just come in and intervene and ask for details that they're not entitled to.
Hi, my name is Tengku Nazran, and I will be continuing with controversial points of views towards child confidentiality in attaining psychological counseling. Now, there are various points of views towards confidentiality in child counseling. While it aims to provide support to children, the management of these tensions is not easily done, as contradictions and confusions arise. Through our comprehensive study, we found that several psychologists have noted the two major consistent factors that circumvent around child counseling confidentiality around the world, which are cultural competency and age of consent. From these factors, there are two cases that make up for thorough explanation on both. In the West, child psychiatrists are better accepted as there are strict laws about confidentiality and almost every issue in psychotherapy, which is lacking in developing countries. In some Indian societies, the common belief is that children hide nothing from their parents and that parents must know all when it comes to their children's problems. In fact, it often hurts the parent's ego when the child thinks of going to a counselor. Parents feel that child has no confidence in their parenting and prefers to take internal problems outside rather than at home. The notion of a child seeking psychological help in India is seen as just gaining recognition, and it will be a few more years before a fuller acceptance ensues across the country. In a more specific case, a 14-year-old therapy client had been accompanied by her mother to her usual counseling sessions and presented complaints of nausea and vomiting for 2 weeks. After her mother leaves the room, she admits to being sexually active with her boyfriend and missed a period. Her parents do not know she is sexually active, and she doesn't want her mother to know that a pregnancy test had been done. The results of the test had come back positive. In the end, she requested for the counselor to preserve and respect her confidentiality. Coming up from these two cases, we have a clearer picture of how the two factors come into play. Psychotherapy for youth is affected by cultural climate around varying nations, while there are specific approaches that must be followed when dealing with youth consent, which itself depends on the policies set by different countries. With that in mind, confidentiality and child counseling in general is perceived differently across the globe, through differing legislative viewpoints. The usual benchmark of all child psychotherapeutic guidelines is set by America. The American Counseling Association ACA code reminds counselors that when dealing with child clients, they must be sensitive to the cultural diversity of their families, and not to engage in discrimination towards culture, religion, spirituality, or sexual orientation. Counselors may encourage clients to even challenge familial and societal obstacles to their growth and development. Additionally, some states in the US extend additional privacy protections to minors that go beyond the Health Insurance Portability and Accountability Act, HIPAA. For example, California gives minors the right to control their own healthcare information. When a state offers a child more privacy rights than the child has under federal law, a therapist must follow the state law. Without disregarding other nations, these American policies are not widely accepted around the world. An opposed example comes from Australia. Taken together with the provisions of legislation such as the Minors Act, Australian courts would not regard younger adolescents to be capable of giving voluntary informed consent to the provision of counselling services. With young children, the welfare of the child is usually the overriding consideration. It could be argued that if a child expressed a wish that some information remains confidential and this wish appeared to be detrimental to that child's general welfare, then the counselor should be justified in making appropriate disclosure of the information. Elsewhere in Canada, under the age of 15, children are generally not assumed to be competent to hold the right to consent. Though the works of persons like Piaget, Kohlberg, and Gilligan, an appreciation has been acquired by Canadian psychologists towards the cognitive and moral developmental stages. However, it cannot be assumed that the child's developmental stage matches their particular age range. While this seems to be the case for countries that hold more control and oversight towards children's rights, there are still nations providing children more agency. Australia's neighbour, New Zealand, has set their affirmation that there is no particular age at which a child can consent to health and therapy services. The relevant question does not focus on the age at which a child may consent to services. Minors may authorize therapeutic treatment if they are matured enough to understand what is proposed and are capable of expressing their own wishes. This is also in direct contradiction to Canada's standards, whereby the understanding between biological age and mental age is approached differently by both countries. Additionally, in European countries like Austria, Belgium, the Czech Republic, Estonia, Germany, Luxembourg, and Sweden, there is no fixed minimum age requirement for consent to psychotherapeutic treatments. Each case and situation is treated individually depending on the maturity of the child.
Assalamualaikum, my name is Nurada Iman and I will be presenting the ethical implications for ethical issues in child counselling. So firstly, what are ethics? So ethics mean the moral principles that control or influence a person's behavior, a philosophical discipline that is concerned with human conduct and moral decision making. So in Malaysia, we have these codes of ethics called Code Etika Counselor Lembaga Counselor. It was published by Lembaga Counselor in 2011, and the purpose of this is firstly a guide for counselors to have a professional guide between a counselor and a patient. Secondly is to elevate the professional standards for the counselors, and thirdly is to protect the counselors from any legal actions that or any false accusation that might be pointed to the counselor. And fourthly, to protect clients from unprofessional actions that might have been done by the counselor. A few key takeaways in Code Lembaga Counselor is they emphasize on instilling trust and as a key in a bond relationship between counselor and client. And one of the ways to instill the trust is to ensuring we provide a safe space for the client and respecting their privacy and confidentiality. And the second point is that the counselors must brief the boundaries to client and clients, parents with respectfulness and efficiency accordingly while taking into account their custom or their culture. So when can counselors break confidentiality? So when breaking confidentiality, there are big consequences if the patient's or the public's safety are in jeopardy. So all of these guidelines that state that the permissibility of breaking confidentiality is reasonable as it not only for the safety of the public, but it is also for the safety for the client. So disclosing this information to their family members in accordance with the possibility of suicide or self-harm. We must understand that confidentiality is about protecting one's secrecy and fulfilling their wishes. So by this, it means that the professionals do not disclose any information about someone unless the individual has given their permission or is absolutely in a required or urgent situation. In Malaysia, there are strict laws regarding confidentiality, and we also recognize that it may have to be broken at times, especially for the protection of the client. Firstly, is with patient's consent, such as the request, such as sick notes or occupational health records. Secondly, is imminent threat of harm to the patient, such as suicidal thoughts or suicidal intention. Thirdly, is express threat to others from violence. Maybe they talked about inflicting harm to their family or to the public. And then we have notification of certain infectious diseases such as cholera, typhoid, or HIV. And lastly, it's required for the counselors to break confidentiality when it is by court order or required by law. This is maybe due to the suspicion of terrorist activity, injuries or stabbing, reporting details of someone involved in road traffic offense. So in any case where we break confidentiality, firstly, the counselor must inform the patient that they will disclose their information. However, the information released will be the minimum required to satisfy that needs to be disclosed, such as solely their name. Then we have counseling dilemma. So a dilemma is defined as a circumstance that is perplexing because a decision is required between equally unacceptable or unfavorable choices. An ethical dilemma incorporates the concepts in preceding definition and is a situation in which there is an apparent conflict of moral standards or imperatives. In essence, to uphold one standard would mean violating another. So during these counseling dilemmas, the counselors must take into account these universal moral principles, which is autonomy, non-maleficence, fidelity, beneficence, justice, and veracity. So what are the consequences of not maintaining confidentiality to person or to society? There is an expectation where confidentiality are kept in medical settings, and this is to ensure the trust in times of sickness and in illness. And due to the inequality in intimate disclosures, medical care providers have a special obligation to be trustworthy and loyal. So when breaking the confidentiality, it may have a negative impact to the relationship between the client and the counselor, because they will less likely to entrust these intimate details to their providers if their information might be revealed. Thus, routinely breaking the confidential of the client harms the therapeutic relationship. So for example, people who are at risk for HIV may not seek testing if they think that their information will be leaked to the other doctors. So without the assurance of confidentiality, no notification of people at risk can happen. How to overcome the counseling dilemma is, firstly, the counselors must identify the potential problems from as many perspectives as possible. Next, they must recognize all potential issues or concerns involve all relevant parties. Third step is counselors are to review the relevant ethical and legal codes and identify points of support. Fourth step is the counselors must generate a list of probable courses of actions. So from this list, they have to select one action. From this list, counselors will select one action to act upon. It is at this point in the process which they must seek consultation from their peers. Final step of ethical decision making involves executing the course of action, evaluating and documenting the results.
Okay, I'm Miss Farisa, your cutest teacher, lecturer. Okay, standard procedure. Alright. Of course, I have to comply with the standard procedure of my workplace where I basically where I do my therapy session or my counselling session. Yeah. But there are two. Yeah, there are, of course, the standard procedure. I think more or less similar to typical standard procedures of other counsellors, but there are two. These two standard procedures are very much necessary and compulsory for me to do, and I think it is also important, and also it is important to make sure that the parents, the clients, and even myself, to make sure that everyone understand about this confidentiality, because sometimes when we provide the informed consent and everything, something like that, they might not even read it, they might not even understand what's the content of this of the letter. So one of the things that me and my colleagues, that the procedure that we have to comply is that we have to make the parents understand about my role and also my responsibility. So I have to explain to them directly, to the parents, of my role and my responsibility as the psychologist or as the therapist, okay, in which I am bound to a very strict responsibility to protect the information of my actual client, which is the child. But then of course many parents feels that they don't understand this, because they feel that they have the rights to know of everything, and then they feel that the kids they shouldn't have the right to to decide by their own because they are just kid. Yeah, but then for us, as to a child psychologist, we believe that every child have their rights to to stand on their own. Yeah, and they have the rights to share something to us. Also, we as a psychologist, me as a psychologist, I know I have this strict responsibility. I am bound to this strict responsibility to protect the information of my actual client, which is the child. So the initial phase of my session, yeah, I will take one session just to inform, just to discuss, just to explain to them about this nature, because many parents don't understand this. Yeah, that's the first standard procedure that I have to comply. The second standard procedure that I have to comply is that sometimes we have to discuss, we have to consult, we have to do consultation with our colleagues. Whenever we discuss a problem to our colleagues or to other psychologists or therapists, we have to make sure that we have to be very careful not to disclose as much information that could leak the identification of the parents or the identification of the client. So we have to be very careful, even though yes, they are also psychologists, they are also therapists, but we have to respect this information, the things that only necessary. Yeah, so I have to be very careful as well, so to only discuss the necessary information whenever I do consultation or whenever we do discussion with other colleagues or other psychologists. Yeah, so basically that's the two standard procedure that I have to comply. Yeah, but usually only the final report, only the official report, I have to ask someone or my supervisor, for example, to evaluate first, then only we can share the report to the parents. But usually the things that I share to the parents is only the official report. Yeah, maybe explaining about the developmental of the client, for example, the milestone of the client, for example, the current mental health state of the client, something like that, very general in nature. But then the real record that I have every day, the everyday therapy session, of course, parents doesn't have the authority to read that. I keep it myself, only to myself. Only when some things happen, when I have to disclose it, and due to maybe some sometimes we have to do a discussion or consultation with a professional team, yeah, to plan a intervention approach for particular clients. So sometimes I have to disclose some things. So sometimes I have to weigh the benefits and the cost and the benefit of sharing the information. But most of the time, the daily therapy session, the report or the record from daily therapy session, what are the things that we talk about, something like that, yeah, the secret, their secret, the secret of the client, something like that. All those things are not being shared usually to the parents. Yeah, the report will first be being evaluated by my supervisor usually. So we discuss a few things. If let's say there are a few things need to be improved, counselors or psychologists or therapists advise to avoid multiple relationship or to avoid dual role relationship. Yeah, so this scenario of mine, yeah, my experience is that when a friend of mine, a close friend of mine, asking my help to help the child, to help my best friend's son, yeah. So this is a trap actually that I should avoid. I even know that this is a trap for me, and then I should find another alternative or solutions to help my friends. But because of empathy, and feeling sympathy to my friends as well, so I try my best. Maybe I this ethical thing, about this dual role relationship. I would just want to help my friends, something like that. So I involve myself in this problem. There are misunderstanding and conflict between me and my friends. Yeah. So by now, yeah, as of now, I will avoid at all costs. I will avoid. Selamat berbuka puasa everyone, and Ramadan Kareem. Assalamualaikum and bye bye.
Hi and Assalamualaikum. My name is Putri Jasmina. I'll be presenting about the legal implications to clients, parents and therapists. What happens if we break confidentiality and who do we refer to? So first of all, we should refer to the HIPAA, which is the Health Insurance Portability and Accountability Act. What they do is they are a major federal statute that governs medical confidentiality. It protects and safeguards minor clients from third-party disclosures who are technically not their parents. So they require healthcare providers, including therapists, to respect the privacy of the patients. Then in the US, they refer to the statutory law, where the US Congress and state legislatures pass legislation to establish it. So these mandates contain much of the framework of wellness, mental health, and education, as well as many of the laws that regulate their implementation. And next we will talk about Perkama. In Malaysia, we call it Persatuan Counselling Malaysia, Perkama for short. So the topics being discussed include current issues in counselling, Counselors who work in the field of assistance and counselling, or interns, they have only one counselling association, which is PERCAMA. It functions under guidance and counselling, and technically anyone can be a part of PERCAMA members. They have conducted seminars and workshops that support enhancement of counselling knowledge and skills. So this is the place where they want to sharpen their skills and possibly learn more about ethical codes and stuff like that. So all interns or practicing counsellors should be actively participating in such programs coordinated by local professional associations. So here are the examples of such situations where violating confidentiality could be justified. First of all is public health considerations. When a client suffers very terrible disease like virus, HIV, COVID even, the counsellors actually can refer to a hospital because it actually brings some risky situations to the others. So then when harm is involved is when the client attempts to do harmful stuff, such as being suicidal or being very aggressive all of a sudden, then we should refer to a police or the hospital. So with that, confidentiality is broken. And thirdly, conditions that pose a danger to other people. Just like the second one, when a client attempts to do dangerous things and emit violence, then we should actually call someone to arrange that. So lastly, where confidentiality can be justified is child abuse. Duties are to the child. To report parents is not to break confidentiality, but to uphold your duty to give priority to the best interests of the child. Some laws, like the state laws, require healthcare providers to report suspected neglect or abuse to child welfare authorities. So next we'll move on to suggestions. What happens to the law, relationships, and other laws. So in here we can see that there are 6 suggestions to secure professionalism, in which a counsellor needs to be professional at all times, no matter the situation. Firstly, practice guided supervision within the limits of your abilities. So it depends on which organization you've been through, but you must have learned something about ethics. So second is we should be familiar with our law or any general law outside Malaysia in order to be familiar with privilege. Third is to clarify your policies concerning confidentiality with both the child and the parents. And if you want to consult with a minor without a parent's consent, we should have the child sign an informed consent or informed assent. Be aware of the possible legal repercussions if we want to do that. The fifth one is to keep detailed notes of all consultation and therapy sessions at all times. So even if there is some minor notes about the child or the client, we should actually keep it to ourselves so we can refer to it at all times in the future maybe. And finally, make sure you have enough professional liability insurance. Adequate coverage is not the same as minimum coverage. So that's all for me. So we'll be jumping to conclusion, and Alia will be talking about that. Thank you.
For conclusion, from the researchers looking at the case studies, ethical codes, legal codes, we've made a few points here. So the first one is no matter if children have or do not have the right to consent, the child's client well-being must be the top priority of the counsellor. As you know that the children or adolescents, not until up to their legal age, which is 18 years old, they do not have full consent of what they want. It's mostly their parents. So as the counsellor, they must ensure that any actions that they take is the best for the client. So the Malaysian Board of Counsellors and PERCAMA as well as the academic facilities that educate potential counselors, are responsible for ensuring that all practice counselors are aware of the warning messages contained in the Professional Code of Ethics in Counseling and the Counseling Act 580. Okay, that's it for our presentation. Thank you.